Good evening, ladies and gentlemen. Law Essentials welcomes you to the webinar on advising clients entering the fashion arena, perspectives from US and India. We are delighted to announce the guest speakers for today's session. Ms. Joan Bellefield Davis. She's an entertainment and fashion intellectual attorney from USA. She practices at Schroeder Brooks Law Firm PLC. We also have with us Advocate Sushanth. He's a cyber law expert and techno legal consultant. He is also the CEO of Sushanth IT Law Associates. Thank you so much to both the speakers for joining with us here today.
Hi, good. It's actually morning here in the U.S. So good morning to everyone. I hope you have been having a good weekend. I'm just going to ask Mohammed for a second. Am I coming through okay?
Perfectly, ma'am.
Good. Okay. So I am an entertainment attorney here in the U.S. And I practice in all different areas of entertainment. Primarily, though, my focus is on fashion law. And a big part of practicing fashion law is intellectual property, or sometimes we refer to it as IP law. I know that most of you are students or practitioners there in India. So I'm going to try to explain to you in a way that you can understand how we use intellectual property to protect fashion designs in the US, which will become important to you as you're crossing the lines and practicing in the US. So intellectual property consists of trademarks, copyrights, design patents. We also get into trade dress, which is a lot like trademarks, except it has to do with colors and not exactly the words or logo mark. So I'm going to explain all of that to you today. And then I think we're going to take questions after we hear the other guest speaker. So intellectual property plays a huge role in what's been defined as fashion law. IP rights allow designers to gain a financial benefit and recognition for their creations. And the IP protection is used to protect a designer's brand. I believe a designer's brand is the most important part of intellectual property they own, at least in the US. I've also presented in Europe, and I understand European law has more protection for copyright on designs, but we do not have that in the US. It would be hard to get any type of copyright protection for a design of a dress or any type of clothing. So it's really, in the US, your brand and trademark protection is very important. So I also know you have been provided an outline that you can use. You can just go through. I'm going to skip around, but I thought that may help after the presentation is over for you to go back and review. You can find a lot of the answers on the internet, but it's just a basic outline explaining IP and fashion design. So we're going to start out with trademarks. And I'm sure you're familiar with what trademarks mean in India. Here in the US, when we're talking about trademarks, we're talking about the brand or the logo that identifies the product. For example, with Chanel in fashion, there's the interlocking C's. I'll try to show you that up there. So when you see that, you immediately identify that with the products that are associated with Chanel. So you as the consumer would expect to get the actual item, not counterfeit or knockoff product. Okay, there's a very important case in trademark law that deals with actually trade dress, because it actually set a holding for, or set the precedent for, a color becoming the trademark a registered trademark. So the case is Christian Louboutin versus Yves Saint Laurent. The case is out of the Second Circuit in New York. I don't know if any of you have ever heard about this case, but what happened was Christian Louboutin, who's a famous maker of women's shoes, created this shoe with a red bottom. And another famous maker of shoes, Yves Saint Laurent, created a monochromatic shoe with a red bottom. Christian Louboutin sued Yves Saint Laurent for trademark infringement. The argument that Christian Louboutin was making is that the color on the bottom of the shoe and the way it's placed created a trademark, so that when you see someone wearing these shoes with a distinct red color on the bottom, you know that it is Christian Louboutin. So the case ended up going to court, and the Second Circuit Court concluded that by placing the color red in a context that seemed unusual and deliberately tying that color to the product, Louboutin was worthy of trademark protection. But they also found that Yves Saint Laurent did not infringe on on Christian's trademark because their shoe was a monochromatic red shoe, had a red bottom, and also the shoe was red. So it wasn't distinct. The bottom of Christian Louboutin's shoe is a red lacquer, so it's shiny, it's different. It's very different than what was on this monochromatic shoe. So I like to say that this particular case was a win-win situation for both parties, because Christian Louboutin did have a trademark. They established the fact that they have a trademark in that red bottom shoe. However, Yves Saint Laurent, with its monochromatic shoe, did not infringe upon Christian Louboutin's trademark. So they could continue to sell the monochromatic red-soled shoe. This was an important case in the US because it defined that a color could actually be a trademark. And in the past, a single color had not been held to be a trademark. So what this case did was set precedent in a way that allows parties to, it's not just the color, but also the other circumstances and facts surrounding this particular color. And this is called trade dress. Although it's registered, it's under the USPTO as a trademark, it's considered trade dress because it deals with packaging and colors and the look and feel of the item. So that's an important case. I think that the citation should be in your notes so you can read the full case if you wish. So that's one example of trademarks in the US. And I have again, just to recap, it's perhaps the most famous trademark case regarding fashion law in the US. This is just, again, Christian Louboutin, a designer of high fashion women's footwear and accessories, painted the outsoles of the high-heeled shoes with a high gloss red lacquer. And it wasn't just the color, it was also the fact that it was lacquer that set it apart from other shoes that may have a colored bottom. So that's the Christian Louboutin case. I would definitely suggest that you read through the case and look at the reasoning that the reasoning for the court's holding. Let's see. The next area of law that I want to discuss that we deal with in the US is copyright law. Copyright protects original works of authorship that are fixed in a tangible medium. A designer often registers prints that are displayed on their fabric, but in most circumstances in the US, they will not be able to register the actual design. From what I understand, this is very different than in the European Union, where I'm not I'm not licensed in Europe, but I understand that in Europe, you can register a design under, I think, the Design Protection Act. It's another area that you should research. But in the US, we don't have that. There's been a bill becomes a law here after it goes through a process, but there has been a bill and for several years trying to get some sort of protection for designs, but it has not been passed yet. So we are still dealing with what we have, which is very little protection for designers under copyright law. The one area that is protected under copyright law for designers is prints on fabrics. So if you have a designer who's creating a print on fabric, and we're going to get to that case in a minute. Okay, I'm just fast forwarded here. So if you have, as you can see in the shirts that are, the men's shirts that are on the slide, there's colorful prints are like works of art. They are given copyright protection. So if you have a client who has created some sort of design artwork that they have on a shirt or a dress or any type of clothing, you can actually register that print with the US Copyright Office, but you cannot register the design. Let's see, just to drive that point home. So there's a case that came up a few years ago, and it actually went all the way to the US Supreme Court. I went and listened to the arguments, and it was very interesting. So the case was Varsity Brands versus Star Athletica, and it dealt with cheerleading uniforms. So Varsity Brands had sued Star Athletica due to copyright infringement of their designs. The plaintiffs, Varsity, registered their copyrights for graphic designs that appear on their cheerleader uniforms. And the defendant, Star Athletica, who also sold cheerleading gear bearing graphic designs that, according to Varsity, are substantially similar to their designs. So we'll go back and you'll see the designs that they were arguing over. So they're basically stars and stripes, chevrons and the placement of the chevrons and stripes on these uniforms were what the dispute was regarding. So the question for the appellate court was whether the pictorial, graphic, or sculptural features that are incorporated into the design of a useful article. Here in the US, we consider clothing a useful article, and usually it is not subject to any type of copyright protection. In this instance, though, the court was looking at the fact that these designs, could they exist apart from the cheerleading uniform? So one of the tests that they looked at was if you took these chevrons and these designs off of the uniform and you placed them, could you place them on the wall, and then would they be subject to copyright protection? And the court looked at a number of factors and trying to decide if these uniforms were just utilitarian or useful, just as clothing, or were they actually more artistic expression worthy of copyright protection? So what happened, they looked at things like the way the chevrons are placed in the fabric, did that serve some other type of purpose? And what they found in looking at all the facts is that actually the plaintiff created these designs off of the uniforms. So before they were ever placed on the uniforms, they were created and then placed on the uniforms. So they were worthy of copyright protection because in the court's mind, you could take those designs and they would be eligible for copyright registration separate from the useful garment, the clothing. So that was the holding and Varsity Brands versus Star Athletica. That was a very important case. I think it was mostly important because designers and those in the fashion industry here were afraid that some of our protection for designers would be taken away. It really didn't give us any additional protection because we've always had protection on prints or designs on or off of clothing. Just as I showed you the prints on the shirts. These have always been protected under copyright protection. So, but it just affirmed that, and I think the members of the fashion community were afraid that small amount of protection could somehow be taken away. So it ended up being an important case for those reasons, although there wasn't really a lot of change that happened because of it. So to recap, Varsity did demonstrate that that Star Athletica copied their protectable elements in the uniform designs. And so they were able to register that with the trademark office. One of the reasons why you want copyright protection here in the US and you want to register your copyrights, it's just like with trademarks in the US. You can have what's called common law trademark or copyright protection, which basically means that even if it's not registered, you can still assert protection that you own the copyright and items. The difference is if it's registered with the Copyright Office or trademarks with the Trademark Office, you get some additional things. You get statutory damages. It's proof to the world that you actually own the intellectual property in those items. For example, if you did not register your trademark, but you had been using it for years, so you asserted that someone else starts using your trademark and your argument is, I've been using that forever on my brand, at least for 10 years, I have common law trademark rights. Well, so the other person, the opposing party who is infringing on your trademark has registered it with the USPTO. You didn't see it in the official gazette. You made no claim to your mark. You're the one who now, or you for your client, is having to defend that mark. And what I mean is, if you had registered the mark, it's sort of like, the way I can explain it in simple terms, it's notice to the world that you own that mark. You've registered it, just like with the copyright. If you do not register it, then you have to prove yourself. So you become a defendant. You're on the other side. You spend more money in courts, whereas it's easier for your client or yourself to register the mark, to register the copyright. That's the main reason for registration. You also get attorney's fees if you sue successfully in court, and we all know that it's nice for clients to have attorney's fees awarded in a lawsuit. Those are available through if your mark is registered or your copyright's registered. So I just wanted to back up and let you know why you want to encourage your clients to register their copyright registrations and their trademarks. Okay, so let's see. One other item that I'm going to talk to you about in the US that we deal with are trade secrets. And that's in the fashion arena, trade secrets are not registered. It's not like copyrights or trademarks or patents. Trade secrets are secrets of the trade. For example, if you went to work for a company and you knew recipes or you knew what the new designs were coming out the next season, one of the things that most employers would probably get you to sign is in your employment agreement is that you wouldn't reveal those secrets to anyone else. So trade secrets deal with confidentiality, non-compete, and non-disclosure agreements, and they're signed by those who are exposed to secrets in an effort to maintain confidential information that is not available in the public domain. There is a case that you can research. It's Nike Incorporated versus Dennis Dekovac and Mark Dolce. And I have that. If you Google that, you should be able to find it. It was a group of employees who took trade secrets to another employer and actually were sued. They were sued by the employer, and the employer won as far as the damages for those parties infringing the trade secrets. Okay. The last area of intellectual property I'm going to talk about in the US are design patents. I have a lot of clients coming to me that don't know the difference between copyrights, trademarks, or patents. So that's one of the things I try to do is educate my clients initially, my fashion clients, about the differences so they understand. Usually in the US, the design patent is probably the most expensive form of intellectual property. It's going to cost more than registering a trademark or copyright registrations. According to the United States Patent and Trademark Office, a design consists of the visual, ornamental characteristics embodied in or applied to an article or manufacture. In the last few years, patents have become more popular as a method of protecting fashion designs. The design patent is probably the most expensive form of protection for a designer. There is a case out there that I would encourage you to research. It's Lululemon Athletica versus Calvin Klein. I'm not sure if you're familiar with those brands. Here in the US, Lululemon is a athletic wear chain store. They sell high-end athletic wear, very expensive. And in this particular case, they were able to get a patent on yoga pants. So what they were arguing over is the waistband. So I just wanted to show you that quickly. I'm going to go back, tell you more about the case. 3 design patents were at issue, specifically the ones that protected this elastic waistband. And you can look up this patent after this presentation if you want to learn more about design patents, what they look like. But that is the design patent. So 3 design patents were at issue, specifically ones, could you still see the screen? Just making sure, there you go, okay. Traditionally, shapes and colors of apparel have not been subject to patent protection. And in fact, they've been broadly copied and modified by other designs, and what many designers believe is part of the industry practice. It is this attitude towards intellectual property that makes Lululemon's suit against Calvin Klein a potential turning point for the industry. Unfortunately, in this lawsuit, or fortunately, the parties were able to reach a settlement. So the arguments, there was no precedent decided. But it's really useful if you want to read the complaint. You can learn about what was being argued with regard to fashion and a design patent, even though there wasn't a precedent set, the parties settled, it's still a really good reference. I look at it if you need to draft some type of complaint dealing with infringement of a design patent. It's a very useful educational resource, even though that case was never decided because the parties settled. Okay, I do have some useful resources here. If you want to look up the complaint, you can jot these down. These all give you more information on the patent cases that deal with fashion law. I'm going to leave that there just for a second. Okay, another area of law and fashion that you're going to come across if you are practicing in the fashion arena in the US. It's huge. It's brand licensing. With brand licensing agreements, you're basically licensing the intellectual property. So they allow one party to license its brand to another party, so that party can profit off of the goodwill and the intellectual property that's protected of the brand. The agreement set forth payments, the specific use of logos, brand names, and limitations on the use of the brand. There's a very useful source if you want to write down this link that's at the bottom here, brand licensing useful source. That would help you learn more about licensing. I have a client that I license a certification mark for, and basically she owns the certification mark, and companies all over the US want to use her certification mark on their items, so they pay her a licensing fee. One of the things that's so important in licensing agreements is maintaining the integrity of the brand, because if you don't draft an agreement that is really that looks out for your client, their brand could get out there. It could be sold in places they don't want it sold. For example, if you are the brand owner of Chanel, or actually there was a recent case of Tiffany, you may not want that item sold in a wholesale warehouse like Costco or on Amazon or anywhere like that. So your brand licensing agreements will prevent those things from happening. They will set up where the licensor can use the brand. How much is your client going to be paid for that, and things like that. So I would suggest that if you are going to practice in the US and the fashion arena, you learn as much as you can about brand licensing, because that's the second part after you learn about intellectual property that allows your client to profit from the goodwill and the brand that they've created. So there's one other area that I want to talk about in the US that I deal with a lot in fashion law, and it's counterfeiting, which counterfeiting here is handled both civilly, which means for damages paid to the plaintiff, and criminally, meaning it's also a crime to infringe upon someone's trademark and profit off of it. Designers spend thousands of dollars to create and register their trademarks and build their brands. Counterfeit or knockoff luxury goods cost the US economy up to $250 billion in revenue every year. Most illegal distributors are caught selling online right now and these days, especially since the virus, the pandemic. There's a lot more counterfeits being sold online. Many small businesses and boutique retailers unaware that posting certain images or making references to brand names when selling their product is illegal. For example, many of my clients who are boutique owners, they're just small and they may be local. They don't realize that once they go online, the whole world, they're making a world presence. So if they are selling an item saying it's like Chanel or it's like Tory Burch or one of the other designers here, it's like Gucci, they're actually, they're selling items based off of the fact that it looks like the brand that someone else has created goodwill around and built. So you can't do that here. Many small boutique owners don't understand that. So that's another job, is if you are representing those clients, you're going to have to explain to them that they can't use, I had a client once that was making earrings out of buttons from Chanel outfits. And you can't, that's not, if you're doing that, then you have to be very clear that they are not Chanel earrings. They are recycled and made, upcycled from the buttons. And there's new law now out there because of sustainability and the fact that many people are upcycling clothing. So as a fashion lawyer, that's another area of law that you need to learn about. Sustainability, what is required for labeling when clients are upcycling clothing, using used clothing, selling it, maybe putting their own mark on it and selling it. So they're, I think the bright line rule is you cannot profit from someone else's goodwill. So if I was selling something that I made, but I used Louis Vuitton specifically, say it was face mask, and I was recycling Louis Vuitton purses, I would not be able to sell it that way. I wouldn't be able to say recycled Louis Vuitton face mask. I would not be able to mention the brand, or Louis Vuitton would feel like I was profiting off of their goodwill and their brand. And if there's a lot, if you Google sustainability, upcycling, and labeling, you can learn more about that. It's relatively new to fashion law, at least within the last few years. So back to counterfeits. In the US, there's one case that I wanted to talk to you about, and it was a fake purse scheme. It was actually in the US in Northern Virginia. And it was a woman who created a website, and she sold purses that were actually counterfeit. She was getting the purses shipped to her from Thailand, but she was going into the stores and purchasing true, authentic Chanel, Louis Vuitton. She would get them home and switch them out with the counterfeit purses, take them back to the store and get her money back, and then sell the real ones. Eventually, she was caught and prosecuted. I think she ended up having to spend, I think she was given 30 months in federal prison and deported to Thailand, or that was part of, she was going to be deported. So you can also look up that case. I know that we don't have that much time left, but if you Google her name, which is here in the first line, you should be able to find the information about that particular case. The other area that we deal with that's not in really intellectual property, but it's another area that we deal with here in fashion law in the US, are fashion models and the law. So if you're hiring in the US since 2013, if you are hiring a young model, you have to be cognizant of what labor laws are in place in New York and other cities across the US. In particular, I'm very familiar with the New York child model law, whereas if you have a client who is a designer who is hiring a young model, there are certain things that have to be provided to the model under New York law: a tutor, a trust fund, things like that. And I have a link here where you can look up a brief overview of the child entertainment laws for each state. So if you are practicing law here in the US and your client happens to be a young model, or you are going to represent a designer who wants to hire a young model, you need to make sure that you're aware of the laws that are going to regulate the use of models under the age of 18. Let's see. Another good resource for you, if you are representing models, is the Fashion Alliance. The Model Alliance in New York is a non-for-profit labor group that helps models in the American fashion industry. So that's also a good resource for you to reach out to if you happen to be representing a client who is a model, or even a designer who is hiring a model. So you're aware of what laws you need to be aware of for that. Okay, all right. I think that pretty much wraps up my presentation. I've enjoyed talking to you guys, and we'll look forward to answering any questions at the end. But see, Mohammed, yes.
Thank you so much, ma'am. I think it was a wonderful presentation, and the audience have really loved you throughout the course of your presentation. We will, of course, be taking the questions coming up, and then I would request the audience who are watching this session to put forth your questions in the chat box available. I would now like to bring on Advocate Sai Sushanth Samudrala to switch over to his presentation.
Thank you, Farhan. A very good evening. It's evening in India, so very good evening to all the participants and viewers of this program. Once again, would like to thank Law Essentials, the Center for Intellectual Property Studies, and specifically Farhan for this early thought leadership on coming up with this wonderful topic on actually trying to come up with advising clients in the area of fashion, specifically from an intellectual property perspective. I think the earlier speaker had a very good approach, and then more or less has covered almost all parameters relating to intellectual property in the fashion industry. But I thought I should just dwell upon a couple of things from an Indian legal perspective, so as to ensure that we are also talking about some kind of intellectual property related protection measures in India. So this is a small context that I thought I should set forth as we go forward. Can we go to the next slide, please? Yeah, so primarily I would just like to focus on what kind of laws are actually trying to be a major role in kinds of protecting intellectual property when I talk of fashion industry. And I believe that Copyright Act 1957 and the Designs Act 2000 would be playing a very significant role as far as protection of IPR is concerned. Of course, we do have the trademark law also that is going to be applicable, but my whole presentation that I thought I should share here with you is mostly talking about the copyright and the design related issues. So when I talk of these two, primarily I just want to talk to you about what kind of articles under the fashion industry are protected under these two, so as to give you some kind of an overview on what's protected and what's capable of getting protected under these particular laws. Now, when you look at copyright, I think we are very fundamentally clear that we have something called artistic works. So any drawings, sketches that you make with regard to designing of any kinds of fashionable clothing, whether it's I've put up saris to just represent India because that's quite I'm talking about the Indian perspective. So just to tell you that any kinds of designing that you do, like sketching and all of these, become artistic works. So therefore, once it becomes artistic works, it becomes capable of getting protected under copyright law. So when you talk of the copyright law in India, we have the Copyright Act 1957. The amendments have been made, and some stringent provisions have been introduced in the amendments, which talk about providing very stringent penalties to people who are indulging in any kinds of infringement activities. And just to highlight the fact that the Designs Act 2000 gives you some kind of protection for designs. So what necessarily becomes a design is anything that you create, probably out of the design and shape. So anything that has a particular structure, it is capable of whether it's a 2D or a 3D model, whether it has some kind of a pattern, shape, and all these things are capable of getting protected under the Designs Act as designs. So fundamentally, the debate that's arising between the fashion industry is what happens, how do I protect my designs, and how do I protect my work, specifically the innovative and creative work that I'm actually engaging, putting in a lot of R&D and putting in a lot of effort when I talk of designing, either it's clothing or whether it's any kinds of jewelry or whether it's any kind of footwear or anything like that. So anything that goes on with the fashion, I believe that these two are something that you'll have to be really aware and cognizant of when I talk of from protection from an Indian perspective. So one thing is that see, in a nutshell, I can tell you something like this: if it becomes an artistic work, then it's capable of copyright protection. And when once you create a particular kind of a design, if you keep drawing these sketches on a paper, that becomes an artistic work. If you convert the same into a particular piece of clothing, I think that becomes a design. So this is the fundamental clarity that I thought of instilling before I go forward, so that it becomes very easy as we discuss both these concepts. So the mere sketches become artistic works. The sketches getting converted into the clothing become design under the design law. Could we go to the next slide, please? Yeah. So primarily, like the earlier speaker was talking about, I would just like to tell you three major important aspects. Rather, put it this way: four major important aspects that people need to be aware of in the fashion industry. Number one, whenever you create any particular piece of article, whether it's clothing, whether it's any other material, I think one of the primary aspects you'll have to look at is trademark, because you will definitely be branding them under a particular brand name, and you will start selling those articles under this particular brand name. I think when I talk about that, trademark invariably becomes a very important aspect as it protects the brand name and the logo. So when I talk of trademark, I can tell you that any logo or a combination of logo and text or special characters get capable of getting recognized as a trademark under the Trademarks Act. So the moment you register a trademark, I think you can start expecting legal protection from the date you file the application, and not from the date actually from which you actually get the trademark. So the law gives you wonderful options. So just to file a trademark, it just takes a day or so, and from that day onwards, you can start using the term TM beside your brand name. And no matter the process is a bit lengthy, it might take a year and a half or maximum 2 years for you to get your trademark registered. But not to worry, the legal protection starts from the day you actually file your application. So you have the legal remedies available. You can exercise your legal remedies by way of sending a cease and desist notice, or you can go and take an injunction order in the court of law in case somebody is actually trying to breach or infringe upon your trademark. So this is something that the Indian law gives you as part of trademark protection. And coming to this wonderful case, I thought I should just take you to some of these cases. So this is a very famous international brand, Louis Vuitton. I think this case talks clearly about the kind of trademark infringements and the kinds of legal remedies being initiated by the Indian courts in case of any trademark infringement. So in this particular case, the Delhi High Court has actually tried to restrain the defendants, and they have actually tried to initiate infringement and passing off charges. Now, what is passing off? In simple terms, any deceptive use that you're making of any particular brand name, which is a trademark, or which is registered as a trademark, or which is filed as a trademark, that constitutes to be passing off. And passing off is also criminal in nature, because you have a deceptive use, and infringement is also there. So therefore, because look, when you look at these identical issues here, Louis Vuitton and LV, see, we have in India something that we do called a prudent test, which means what? Which means that any average person looking at a brand name should be able to first identify the main source. So I believe that Louis Vuitton is very popular international brand, and to an average user, the moment he looks at LV, he is definitely going to relate to Louis Vuitton. So this is one of the major tests being adopted by Indian courts in order to determine trademark infringement disputes between parties, and therefore the court is granted damages by way of compensation. So this is something I would like to start off in the fashion industry, because today, when you actually try to sell your fashion clothing on platforms like Amazon or Flipkart and any other e-commerce and marketplaces online, one of the primary aspects that they would ask you is, have you registered your trademark? If so, please send us the copy of the acknowledgement. So recently, we had one of our clients who actually filed, who wanted to sell her clothing on Amazon. She's a fashion designer. She designed some fashion apparels for women, and specifically, we went on to file the application for her, and then we submitted the acknowledgement, and only then she was allowed to sell, and then her products were made available on Amazon after the acknowledgement was produced by from the registry. So therefore, this is just to tell you that this is going to be one of the key essential aspects that we'll have to talk of when you specifically talk of intellectual property right protection in the fashion industry. So this is the context I thought of setting forth as we go discuss further on copyright and designs. Can we go to the next slide, please? Yeah. So primarily, Designs Act by way of Section 2D protects shapes, patterns, and ornaments. So specifically, any 2D or 3D objects, shapes that you create, patterns that you create, ornaments, jewelry that you design, I believe all of these are going to be protected under designs. And one of the major essentials is they must be appealing to the eye. So which means what? Which means that this is one of the key essentials of a design. And designs, one of the major aspects is it should be novel and unique, and it should not be published anywhere. So one of the major issues that arise today here is, what happens if I showcase my work before a fashion show? I think that is something that we'll all have to quickly understand from an IPR perspective. Will my design be registered, or will it not be registered because there is a public showcase happening here? This seems to be a very interesting question. So let's discuss more as we discuss as we go forward. But just to tell you that yes, designs are actually getting more and more protected, and a lot of protection is also granted to you. Just like you have trademark legal remedies, the Designs Act also gives you civil remedies where you can actually try to go ahead and get injunctions in a civil court, and you can also get some kind of compensation by way of damages. So apart from this, now what becomes interesting is one more aspect when I talk of the Designs Act. Now there are lots of 3D designs that have been created specifically using this new technology called 3D printing, which now comes up with a wonderful option where you can actually print 3D printed clothing from a 3D printer. Wow, that sounds amazing. Now, all you require is a CAD file, which is called a computer aided design file, where you do all the designing of that particular clothing using a computer electronically. Fantastic. Now, all you require is a 3D printer, and the moment you insert your CAD file through a pen drive or you connect that to a 3D printer, the design is automatically done. But one of the most essential aspects here is there are going to be n number of infringement related aspects that we'll have to consider. Not just that, today people are using social media by way of as a tool for showcasing their works, and of which Instagram is turning out to be one of the most uh, popularly used social media, where a lot of fashion designers and people in the fashion industry are making use of Instagram for the purpose of sharing their collection to the world. But failing to understand that the moment they've put that design online, I believe definitely it can be replicated, duplicated, and also infringed upon. So before that, you'll have to first understand that you'll have to protect your design, and also seek appropriate intellectual property protection before you actually showcase your collection through the social media. So this is also something I thought I should share with all of you. Can we go to the next slide, please? Yeah. No, apart from that, in the fashion industry, there is also one more form of intellectual property that's going to be very important, which is called the geographical indicators. Well, in India, we have a lot of geographical indicators in the clothing sector. We have the famous Tamil Nadu Kanjivaram saris. We have the kind of, saris from Andhra Pradesh. We have these, what do you say, shawls and things from Kashmir. We have a lot of things, as you're able to see on the screen over there, and the Mysore silk saris, which is typically from Karnataka. So I believe that geographical indicators are also something that people have to quickly bear in mind in case you're trying to come up with some kinds of what do you say, intellectual property which is based on a region or a particular geographical territory. So this is also something I wish to tell you. Just go to the next slide, please. So here's one very interesting case that I thought of sharing with you. Now, copyright versus design. I think one of the key areas are these two case studies, which will be able to demonstrate the kinds of lacunas, and shall I say, the kinds of loopholes in the legal system, as also in some of these legal provisions. So we have this wonderful case called Ritika Apparels versus Biba. Biba is a brand, and Ritika Apparels is kind of a fashion brand, which is also in connection with one of the fashion designers named Ritu Kumar. So what happened in this case was one party had actually tried to copy, and they tried to actually lift the complete design of one other party's creation. They reproduced it and they started selling it in their own name. So the other party, whoever was infringed, whose brand was infringed, they moved to the court. Now, what is the kind of defense that was taken? I think when you look at this the defense, I think this really is an eye opener for all the people who are in the fashion industry. Now, specifically, when you look at the Indian copyright law under the section 15, subsection 2, which says that a creation is eligible to be protected under design law, which has not been registered with any other design authorities, and has been reproduced for more than 50 times by a industrial process. So which means if I make 50 copies of my dress, or the kind of design that I do, then the copyright in that particular product, in the same product, has been completely lost forever. So what does it mean? It means that I cannot claim copyright in case I have more than 50 copies of the same design dress that I actually have come up with. So you must be really careful on the kind of number, because if you don't be aware of the kind of number, I think you're losing out on your intellectual property protection. So what I wish to tell you is that this is one landmark case in the fashion industry when I talk about protection of copyright. And this is also going to be a very important aspect that people have to bear in mind with the number of copies. So that, which means by industrial process, definitely, if for creating a clothing, you would require some kind of an industrial process. You would require some kind of a procedure which you will have to adopt in order to make these copies. So be very watchful on the kind of number. So this is also something I thought I should share with all of you. Can we go to the next slide, please? So what are the key learnings here? The key learnings here is that the same design has to be registered even under Designs Act. So if it is registered under Designs Act, then you will have a total protection of 10 years with an option to renew for another 5 years by paying some additional amount, which is amounting to 2,000 rupees, in 2,000 Indian rupees. And what happens here is that the party was more focused on copyright protection, because copyright gives you a larger term of protection. The life of the author plus 50 years or 60 years, you have a huge amount of protection. But what they fail to understand here is that the immediate protection and the right kind of protection needs to be protected, rather than protecting it for more number of years. I think this is some point that we'll have to constantly be aware of. And if you were of the opinion that you want to create a monopoly, I believe fashion industry will not be the right industry, because fashion changes every second, every minute, and I believe with every passing day, month, and year, new fashions are going to be the new toast of the times. Can we go to the next slide, please? Yeah, so this is one more case called Rajesh Masrani versus Tahiliani Designs. So here there's a claim of the infringement of artistic work. So artistic work again is covered under the copyright law. So what happens here is that drawings, and the defendant tried to argue that all these works again come under section 15(2), which is the 50 times limitation. But the judgment was entirely different. And so the court had given a judgment that these being the original works are capable of getting qualified under artistic works, specifically under the copyright law, section 2C, and then they're not capable of getting registered under Designs Act. So because it's only 20 times that has been reproduced. So what we'll have to constantly be aware is that the originality of the work and the number of times that you actually reproduce the same. I think these are the two key learnings, two different perspectives from the courts when I talk of the protection of designs. So this is something I thought I should share with all of you. Can we go to the next slide, please? Yeah. So, like the earlier speaker was talking about some kinds of issues. I think one of the common issues that we are facing today is the unauthorized use of these works, and more specifically, a lot of piracy is happening across in the fashion industry. And I believe that a lack of knowledge and basic fundamental idea about intellectual property is something that has actually drastically increased the piracy in the fashion industry. So that being so, I think a lot of illegal reproduction and distribution of fashionable items are going across, and primarily we can categorize them into two kinds of areas: knockoffs and counterfeits. I don't want to talk much on this because the earlier speaker already gave you some kind of an understanding on counterfeits. But what becomes very important today is that a lot of counterfeits have been sold across the online domain. So we see a lot of brand infringements happening across, whether it be it in terms of the clothing, or in terms of jewelry, in terms of any fashion articles, footwear, any kinds of apparels, or any kinds of the wearables. I believe that this is the order, and Indians' common problem is that we have this Indian Jugaad school of management, where we think anything and everything given to us can be capable of getting copied, but without realizing quickly that it's not just the kind of charges for actually selling counterfeit products that you'll be accused of, but there are also going to be lots of intellectual property infringement issues that are likely to crop up, whether be it trademark, in case since you've violated the brand name and logo. Then if it is design, then you'll also be charged for unauthorizedly using the design. And if it's an artistic work, lo and behold, I believe you'll also be charged with copyright infringement. Now, the copyright infringement becomes very serious when I look at the copyright amended law, specifically the amendment that has come up in 2012. I think the penalty period is very high, and the compensation is also extremely high. So you could face imprisonment ranging from 7 years to life imprisonment. So that's the kind of legal exposures that you and your organization could be exposed to in case of these piracy issues happening across your platforms. So I think a lot of these online marketplaces today are also bringing in some kinds of counterfeit products, and as a result, there's going to be substantive amount of loss and damage to the original brand owners. And if you're one such victim whom you think that there's a lot of loss that you have incurred, not to worry. The law gives you three kinds of remedies under the law. Number one, you can exercise civil remedies and seek compensation and damages. And number two, you can exercise criminal remedies and you can lodge a criminal case for passing off copyright infringement and things like that. And number three, you can also seek administrative remedies where the police and the enforcement agencies or the court would take would take control of the infringed material and would seize the infringement material from the particular infringer. So these three are the legal remedies that the laws gives you in case of any kinds of infringement. Can we go to the next slide, please? So knockoff is something which is not exactly a counterfeit, but I can tell you that they're sold under a different name. So as you're able to see on the screen, they're imitations or close copies. They also mimic the original fashion design. So I believe that these kind of activities, like I told you, would be infringing intellectual property by way of designs, by way of trademark, and things like that. So I believe that these are just wake up calls, and the moment you try to be more and more aware and cognizant of what's happening around intellectual property laws, I think it's life is going to be more simpler and more easier. Next slide, please. So counterfeit, like I told you, when you have counterfeit, one of the major challenges is you could also be facing criminal charges because you have an intention to deceive. So the two essentials of a crime where mens rea and actus reus, I believe both are there here. You have an intention to deceive, as also you're indulging in a wrongful action, which constitutes a crime under the Indian law. And apart from this, provisions like forgery and provisions like cheating could also be incorporated upon you. And if you're doing the same online, God bless you. The reason is there's also cyber law that's going to be made applicable for you. Let's go to the next slide, please. Yeah. So I thought I should just give you a quick perspectives and dimensions about these because these are going to be primarily the challenges that you'll have to understand from a, legal perspective, designs and copyright and also trademarks. Just to give you some more idea, what I can tell you is that there are a couple of things that I would recommend because there are going to be lots of infringement activities that are going to take place in the fashion industry. And more specifically, please do have work for hire related agreements and clauses which would engage in case you engage any kinds of designers. Because when you look at the copyright law, it's very clearly stating that the designer or the creator of a design becomes the first owner of copyright unless there is work for hire. So work for hire becomes a very, very critical aspect. Number two, please have your intellectual property registered. So if you're having a trademark, if you're having a good brand name, please register a trademark. If you're having sketches and drawings, please register artistic works. Please register a copyright. And if you're trying to come up with a form of your artistic works, that is, you come up with your own designer wear, then I would recommend you to register under Designs Act 2000. So I believe that these three are going to be playing very, very important roles. Of course, we do have the patent also that are going to be playing an important role here. But specifically, when I talk of the fashion industry, by and large, copyright, trademark, and designs would be your three key parameters that you'll have to keep in mind. So with this, I thought I should just give you a glimpse of on the same. And in case you're having registered intellectual property, then you have a lot of a variety of options that the law gives you. You can license your intellectual property for a period, for a particular purpose, for a particular activity. You can license it in part or full. You can sell it in part or full. You can actually try to do any kinds of co-branding related activities. You can try to incentivize your intellectual property. And one of the most key essentials is please have your legal due diligence and specifically under the intellectual property rights law, please be aware that you can protect all of these. It only costs you very limited amount of money, and if you just think of the kind of protection that you have, it's going to be amazing. So all that I wish to tell you is that in the fashion industry, there's going to be a lot of intellectual property going to get generated every day, every hour, because the fashion industry is in India is tremendously increasing. And now with artificial intelligence coming in, it's going to be a completely different ball game altogether. Well, one of the primary points that I just would like to conclude by saying that we already started having artificial intelligence in the fashion industry. Just imagine if a computer creates a design, who owns that particular intellectual property in the design? Second, in case there is an intellectual property breach committed by an AI system, who's going to be legally responsible? Number three, what happens in case your particular design violates some other intellectual property belonging to someone else? How are you going to handle? I think these three are going to be very interesting questions, and I believe we are all on the age of voyage. And once we get transitioned into a new age of artificial intelligence, they're going to be a plethora of legal questions that are likely to pop up and that are likely to bring in huge amount of legal regulatory policy issues, specifically in the area of intellectual property. When I talk of these emerging technologies used in the fashion domain. So this is a small dimension that I would like to just give you. So I am open for questions. Once again, just like to tell you that don't have a 20th century mindset while you're handling issues of 21st century. Please re-innovate yourself. Do not dirty your hands. At the same time, be watchful on what's happening. I think legal due diligence, having some basic legal knowledge on the intellectual property is always going to safeguard you, whatever be the area of fashion, whether it's physical, digital, or both. I believe IPR awareness is only going to be the center of attraction and the kingpin you'll have to be aware of. So once again, like to thank Law Essentials for this wonderful opportunity, as also Farhan for this thought leadership, and also the Center for Intellectual Properties Studies hosted by Law Essentials. So thank you so much for these wonderful opportunities, and I'm open to any kind of questions.
Thank you so much, sir. I think that was an excellent presentation. I particularly found that part interesting wherein you portrayed the different parts of India having the geographical indications wherein different parts had different types of clothings. That was a very interesting thing to look up to. We have a few questions coming in from the audience. I would pose the question on the screen while each speaker can go through the question at the same time. The first question coming in, what are the future prospects with regards to fashion law? I would like to ask Ms. Joan to go first. Ma'am, you'll have to unmute yourself to speak. You're not audible yet, ma'am. On the same line of the share screen, there is a mute option.
There we go.
Yeah.
Okay. Again, I also want to thank you for giving me the opportunity to present this morning. So as far as future prospects with regards to fashion law, I'm thinking that question's probably is about job prospects. Is that what we're thinking about? I think especially as our other speaker was mentioning with artificial intelligence, I think that fashion law is going to, I think lawyers are going to be needed more in the area to define copyright protection with regard to AI generated designs. I don't see, I just see it as a growing, with the counterfeiting, buying online. I think this area of law is going to continue to grow. And I think having the knowledge of intellectual property in this arena is going to be very helpful. I think more lawyers are going to be needed who understand intellectual property globally. So I've learned a lot today about intellectual property in India. I think that it's going to be necessary for attorneys who are going to practice in the area to learn some of the global laws, to make contacts. And in that realm, I think the future prospects in fashion law are, it's going to just grow. We're gonna see more opportunities there, and more opportunities, I think, in a global arena to know more about intellectual property in each different
I would
area.
like to ask Sai Sushanth sir to answer the same question.
Yeah, I believe that this is the age of technology and artificial intelligence, and definitely I see this as one of the very promising areas as we go forward. Because apart from just understanding about intellectual property, I think fashion law also would have elements relating to competition law and commercial law, and also cyber law for that matter. Because we're going to see a variety of different kinds of areas that are likely to crop up, whether it's piracy, whether it's counterfeiting, whether it's infringement suits, whether it's any kinds of fashion related IP protection, any kinds of fashion negotiation related legal issues, any kinds of legal agreements between parties. I think there's going to be bringing forward huge amount of scope. And not just that, now specifically during this period of COVID-19, I think a lot of people are also slowly trying to migrate to the online domain, and we're likely to see a lot of startup communities opening up their doors in the fashion industry. Specifically, I was just looking at one of the startups, who came up with this brilliant idea of designing clothes online. So they have a fashion designer online. You interact, and they design custom specific clothing for you online. So that be the situation. I think each of us definitely feel that we should be definitely unique in our own way, and then we should appeal in a different manner altogether when we present ourselves to the world. That being so, I think fashion law is going to be one of the very great choices as a career option in India. It's likely to see a plethora amount of legal issues, and it's going to be overall likely to do a lot of roller coaster rides are likely to happen as we go forward. Specifically with 3D printing, artificial intelligence coming in, I think it's going to be huge amount of roller coaster rides, because they're going to be a very different kinds of legal paradigms that are likely to emerge with the fashion law in the domain of privacy, piracy, and also emerging technologies.
Thank you so much, sir and ma'am, for answering this question. The next question coming in: are there specialization courses available in any university in fashion law?
Do you want me to take that? Okay.
Yeah.
All right. So I know that I attended a special program at Fordham in New York. In the U.S., I think there are two specific fashion law programs. One at I believe New York, one at Fordham, and the other one at New York. So those programs, there's an LLM, and there's also a certificate program. If you're an attorney practicing, I actually went through the certificate program. It was called the Fordham Law Fashion Law Boot Camp. It was very helpful. I'd already been practicing law for a few years before I enrolled in that course and took it. I learned a lot, and I also made a lot of contacts, which is very important, I think, in this area of law. So I have been researching LLM programs, and I only found 3 that specialized, and 2 were in New York and 1 was in Rome, Italy. So there are courses that you can take that are specialty courses. What I find in my practice of law is you need to be cognizant of all areas of IP. So any IP classes that you're taking are going to be helpful, whether they're specialized or not. Also, contract drafting. A lot of what we do with brand licensing and even contracts to do with labeling. So you also need to make sure that you are taking every contract course you can at your law school, along with your IP courses. But other than that, if you're looking to specialize afterwards, I would look at there's LLM programs in New York and in Rome, Italy. I think it's at Luis. Those are the ones that I am aware of.
Thank you so much, ma'am. Sir, are there courses available anywhere in India for the same?
I believe we have one or two, but I'm not really aware of it completely on the content and how great are they. So I don't wish to tell in the forum here. But just to give you a small glimpse that a lot of material is available online. I think basically what you have to really understand is that you'll have to look at some basic IP related courses and try to understand how you register trademark, copyright, and patents, and also designs. I think if you are fundamentally clear on this, I believe, like how the earlier speaker was talking about contracts, I think being just aware of your normal laws would be greatly sufficient in terms of this. But negotiating fashion-related contracts would require a certain amount of distinctive skill. But I believe that I think I'm not really aware of any specialized areas of courses in India, but I believe there are one or two more happening across, but not really sure on the content.
Thank you so much, sir. The next question coming in. Why is fashion law used interchangeably with intellectual property laws? Do you not feel that a separate domain must be created in order to hold this area of law? Ma'am, you can go first.
Let's see. Did you say for Joan to go first, or?
Ma'am?
Yes. Okay. All right. I'm sorry. I was having a problem hearing you. All right. So I think I understand the question. Why is fashion law used interchangeably with intellectual property laws? Well, I think fashion law encompasses it can encompass many different areas of law. But I think for fashion law protection for designers, you have to, you definitely, there's a connection between it and intellectual property law because you're protecting design. So you're dealing with intellectual property, you're addressing infringement issues. I don't know that there could be a separate area law. I used to think about in the US, we have sports and entertainment law. In a lot of different categories, you see that, but you never see sports, fashion, and entertainment law. I think part of it is because it's really, you're using a lot of different areas of law that you've already maybe had in school or learned in the fashion arena. But intellectual property is a huge part of it when protecting designers or any type of art, like the designer or a brand. But also we see fashion law and criminal law for counterfeits. I've even seen fashion law in estate planning where a designer passes away and does not want their designs sold in certain areas after they've passed away. So I don't know that there could be a separate area that would just encompass fashion law because it touches so many different areas of law, much like entertainment and sports that touches a lot of different areas of law, which is different than just criminal law. Because in fashion law, you're dealing with contracts, you may be dealing with intellectual property as well as criminal law. So I don't think there could be a separate area for it to shorten up my answer.
Thank you so much, ma'am. So,
one of the fundamental areas that I would like to tell you here is that fashion law definitely would have a lot of other legal components as well. But ultimately, as a fashion industry, I'm more bothered about protecting my intellectual property because that's something that I've actually put in a lot of effort whether it's physical, mental, or a combination of both of them. And I believe I've created a lot of value proposition, and that's where the importance of intellectual property comes into picture. So I believe this is one of the critical reasons why fashion law and intellectual property law are used invariably and interchangeably with each other. And of course, fashion law has different dimensions. You would have to look at civil law. You will have to understand about criminal law, because when you seek civil remedies, definitely you'll have to be aware of the kinds of injunctions, the procedures of seeking injunctions in courts, and things like that. Criminal law, when you are when you're filing charges of passing off and other copyright infringement related activities. And then competition law, when you're selling your thing across in the competition or in the domain of the market. And then definitely contracts, when you're trying to work with different players, be it designers, be it distributors, be it resellers, be it anybody, be it even the organizers of fashion show. I think contractual law will be playing a very important role. And of course, well, all this is happening in the physical market. You also need to be aware of actually trying to structure your company, because if you think that your intellectual property should be owned by a company, I think company law also would come into picture here. You also need your or knowledge on company law also is required for the purpose of incorporating a company, because now when you want to sell across your collection across different platforms, instead of selling it individually, if you sell it through your firm, I think that also gives you a different dimension. So I think registration and incorporation of companies also would be one of the essential aspects of fashion law, apart from all of these. And fashion law will also bring in huge amount of online related issues, whether it's the piracy or privacy, or any kinds of blatant copies or anything like that. I think even the knowledge on cyber law is required. So likewise, I believe apart from this, taxation also is going to playing a very important role, because just trying to understand the rates of tax that you're being made applicable for your fashion product, that's going to be very interesting. Because if you're giving fashion as a service, I think that's a different paradigm altogether. The rate of tax will be different. Well, if you're just being a seller, if you're just selling your fashion merchandise, I think the rates of tax would be different. I think these are the different dimensions of the fashion law, and it can be looked at as distinct subject. But no matter of all of these, intellectual property would be playing a very significant role out of all these other laws. So I believe this is also one of the reasons why it's interchangeably used.
Thank you so much, sir. There are many questions coming in from the audience, but I would like to take one last question due to the paucity of time. How can the logos which are available on the free domain be used without any infringement? I think it particularly relates to the apps which are providing the free logos to be
I think
used.
it's an excellent question that's been asked. So I can just add one perspective here. See, when you are actually trying to use the free logos, there are also certain kinds of websites offering free logos which give you some kind of a license. See, if you look at some websites, they tell you that we are giving you a license to use this particular one. So then there is a license being given, and when automatically there is a license terms that you actually agree while actually downloading that particular image. So there's also a contract that is created between parties, and we are hoping that these guys actually own the intellectual property, but they're just licensing the right to use. That's also one area that we'll have to understand. And the second aspect is that when you're trying to use these logos from the free domains, please make sure that you lead the terms and conditions of these particular domain names, because one of the critical aspect is, if these logos are infringed logos of some other brand, and with or without your knowledge you're downloading them, God bless you. The reason is that you will also be put as a party to the intellectual property infringement. I think that's also something that you'll have to be cognizant and aware of, rather than just looking at the free aspect. And apart from that, one last thing that I would like to add over here is that are these free domain owners the original intellectual property right owners? I think that's one of the questions that you'll have to ask yourself, because Usually, sometimes there would be third parties who would be actually trying to negotiate these while they want to make some money out of it, because they will be acting as an intermediary between the original owner and the person who's actually purchasing it. These people may be indulging in any kinds of malpractices. So I believe we'll have to be alive to the fact that don't try picking logos that are free. I would advise you to either look at the license terms, or look at the terms of use, or otherwise, please understand if there are any usage or terms of use, or usage terms given when you're downloading that particular logo. So my advice is all of these three pieces of advice to you, because I'm seeing a lot of people indulging in these kinds of IP related infringement issues, and nobody will hit you now. The issue is that when you get popular, when you start spending a lot of money, effort on branding, I think the exercise would go futile in case you don't take proper precautionary measures and due diligence in the initial level of logo adoption.
Yes.
Thank you so much, sir. I think we can end this session after ma'am answers the same question.
Yes, I would agree with everything that was just said. I think the other thing, it's very important, I can't stress enough, is when you're clicking through these agreements, they're click-through agreements, and you are downloading these logos, you truly need to read the terms and conditions, because chances are you're not being given a free use license. I've had clients come in, even with the stock images that you see online that say free, you have to read through to figure out what is the license for. Many times, if you're using it for commercial use, it's not free. You're not supposed to be doing that. And then I had one client come in who had actually used images off of a free, it looked like it was free. It was an elderly woman. She didn't understand. She had embedded these images in her website and was sued by the company that offered them for free. So you have to be very, very careful. As my father used to say, nothing in life is free. So make sure you read the agreements and the click-through agreements, and if anyone's giving you anything for free, you make sure you know what it is, because I agree. You could be downloading something or putting it out there, and then you're going to be subject to the infringement action, which you don't want. So
I think that was a wonderful way to end the session. Nothing in life is free was an amazing thing I heard today.
I think, Farhan, I would just like to tell you one thing. I believe, I would like to end this in a very lighter note. So I believe Adam and Eve were the first people not to read the terms and conditions of Apple. So I think, with this funny note, I just wanted to end the session.
Yes. Thank you.
Thank you so much, sir. Thank you so much to both the speakers for joining us today. It was wonderful talking to you both. I would like to express my heartfelt gratitude to you for extending your support at all times to the International Center for Intellectual Property Laws and Law Essentials India. Thank you so much for joining with us today.
Thank you. Thank you.
Thank you.
Thank you so much to all the audience for attending this session. Signing off is Mohammed Farhan.